My name is Andrew Nyamayaro. I'm a solicitor at Tanlaw Solicitors based in the United Kingdom. Of late, I've been getting a number of inquiries from both employees and employers in the healthcare sector, particularly for those people that have come to the United Kingdom under the skilled worker tier 2 visa for senior care workers and care workers. It is important that both parties agree at the initial stages of their relationship. That means that a contract of employment should be done, and both parties should understand the terms and conditions in the contract of employment. It appears sometimes some people don't understand what is in the contract of employment, they do not understand what is in the letter of offer, and they do not understand any conversations that have taken place. That can then lead to a number of disputes that arise. In the event that there has been a dispute between the employer and the employee, it is important that both parties be informed and know where to find the information such as the employment contracts, signed employment contracts, policies such as the grievance procedure, the way someone can whistleblow, and any other relevant policies that the company has. Some people do not have access to this information. I don't know why, but they will be part of the employees of the employer. Where as an employee you are not happy with a particular event or with a particular occurrence or what is happening in the company, I suggest that you first of all try to resolve the matter with your employer. You need to have a conversation with them. You need to maybe raise a grievance under the grievance policy, or to raise a complaint and try to talk to your supervisor or the person responsible for your work within the company. We hope that things can be resolved that way. But if things are not resolved in that manner, then it is open to you to then raise your matter through ACAS. It is important to know that here in the United Kingdom, you have got 3 months less 1 day to put your claim or a case, depending on the nature of the claim or a case, because some things under the Equality Act have to be reported 3 months, or rather have been taken to the employment tribunal within 3 months of the event occurring, or sometimes there's to be 3 months of either dismissive or the actual dismissal or constructive dismissal. So you need to have someone who can advise you on the proper grounds, on the proper ways and what is applicable. But the point that I'm making is that you can approach ACAS for mediation, and hopefully through mediation the matter can be resolved. It is important that when you approach ACAS, you have got a position as an employee or as an employer that is there, so that the mediation can go ahead. In the United Kingdom, litigation is quite expensive, and you might be able to get a no-win, no-fee lawyer as they are commonly known, but if you are going to pay your fees, the fees are quite expensive. In that regard, it is important for you to have a legal cover insurance. This you can get it as a bolt-on or as an add-on to your insurance. For example, if you are getting your house insurance, your contents insurance, your car insurance, you can get this legal cover insurance as well, so that it can cover you on things pertaining to your employment, to road accidents that you have, or any other thing that can be bolted onto your insurance. So you have to approach the employment tribunal within 3 months of either the Protected Act happening, or the Equality Act being breached, or when you have been dismissed in terms of actual dismissal or constructive dismissal. In my next video, I will take you through the process of the employment tribunal, but it is important to protect each other, and it is also important for you as an employee to perform your duties in a diligent, committed, dedicated manner. Each person has got a party to play in this transaction, in this relationship. The employer and the employee, at the end of the day, what is important is for the relationship to continue, for the company to grow, and for the employee to get their dues as per terms of the contract. If you want further information, please subscribe to our YouTube channel, which is the name of the YouTube channel is Tanlo Solicitors. And if you subscribe, we've got so many videos on there.